like to thank you for watching my videos, and especially my legal and business scholars. We have spent some time talking about the law of contract. Remember, in our last studies we talked about the different elements of contract. We had a benefit of looking at the principle of offer. We looked at acceptance and consideration. And today I want us to talk about capacity to contract. What is capacity to contract? Who can enter into contractual obligations? It's very important for each and every person who is about to enter into a contract to know the people they are about to enter into a contract with, to know whether they have the ability to enter into a contract. And that is what we call capacity to contract. Who can enter into contractual obligations? Now, number one, we'll begin by looking at the capacity of natural persons. A natural person, that is a normal human being. And there's a lot we can talk about natural persons. But as per Ugandan law, Section 11 of the Contracts Act 2010 is clear when it comes to natural persons. Section 11(1) states that a person has capacity to contract where that person is 18 years or above. So if a person is 18 years or above, you're free to enter into contractual obligations with them because they are above age of majority. They have attained the age of majority under the Constitution of the Republic of Uganda. But if you enter into a contract with a person of tender years, someone who is below 18 years, such a contract is not valid under the laws of Uganda. It is at the will of that person you've entered into the contract with. But what is primary for each and every person to know is that if a person is 18 years and above, then you are free to enter into a contract with them. Now, the same section has part B, that a person has capacity to enter into a contract where that person is A, 18 years or above, and B, that person who is 18 years or above should be of sound mind. That person should be in their right faculties, right understanding faculties. And it is very, very, very important. And C, that person should not have been disqualified from contracting by any law to which he or she is subject. For example, someone may have been declared a bankrupt by courts of law. Now that means that that person does not have any income which can enable him to enter into a contract. That is why the law cannot risk such a person into entering the contract, because chances are high that he will breach conditions in a contract. So he is stopped by court from entering into a contract. And that is also very important. And then Section 11(2) states that, notwithstanding this section, a person of 16 years or above has the capacity to contract as provided under Article 34, 4, and 5 of the Constitution. And that is when a person enters into a contract dealing with necessities of life. If someone enters into a contract concerning necessities of his livelihood, then such a person is supposed to fulfill that condition. We'll elaborate on that further. Now, it is important to note that both at common law and statutory law, the law protects the children, whom we term as infants. It also protects people of unsound mind. Because a person of unsound mind is in a state whereby he cannot enter into a contract. He does not have the soundness of the mind. He does not have the right to judge between the good or bad. So if a person of sound mind enters into a contract with a person of unsound mind, then the person of sound mind is liable. And the other person of unsound mind can walk out of such a contract, because chances are high that this person of sound mind may have taken advantage of that one who was not understanding properly. That is why the law protects people of unsound mind. It also protects people who are in a drunken state from contractual liability. That is very important. Number 2, we are going to talk about persons with mental disorders. Can persons with mental disorders enter into contracts? And I think this is illustrated under Section 12 of the Contracts Act 2010. Sound mind for purposes of contracting. And Section 12(1) is very clear. It states, for purposes of entering into a contract, a person is said to be of sound mind if at the time of entering into the contract, that person is capable of understanding the contract and of forming a rational judgment as to its effect upon his or her interests. And Section 12(2), that a person who is usually of unsound mind, but occasionally of sound mind, may enter into a contract during periods when he or she is of sound mind. So the law is very clear on that. If someone is sometimes of unsound mind and sometimes of sound mind, then he can only enter into a contract in that period when he is of what? Of sound mind. Very important. And then 3, a person who is usually of sound mind but occasional of unsound mind may not enter into a contract during periods when he or she is of unsound mind. Very important. And then we are going to talk about persons with mental illness. Persons with mental illness. Can persons with mental illness enter into a contract? Now, soundness of the mind at the time of the contract is important, because the contract is only valid when freely entered into, and consent has genuinely been given from an informed position. Why can't a person who has a mental illness enter into a contract? Because with a mental illness, you lose judgment. You are not in your right thinking faculties. You can easily be taken advantage of. That is why they cannot allow such a contract. Such a contract is void ab initio from the word go. And it is only voidable at the will of this person who entered into it with illness. And this is very important. Why? Because in the contract there is supposed to be a meeting of the minds, and it is supposed to be at a free will of a particular party. That is why the law is very keen when it comes to people with disabilities, mental disabilities, people who are of unsound mind, people who are in a drunken state. Do they still have the senses to enter into a contract? That's why the law protects such people in vulnerable states. Just like we saw when we talked about contractual capacity of drunken persons, that these are said to be in the same position as the mentally disabled. The level of drunkenness must be such as not to enable the person to know what he or she was doing at the time of the contract. And if that fact was appreciated by the other party, then the contract is voidable at the instance of the drunkard. He can, however, ratify the contract when he sobers up. That is also very important. And number 4, we want to talk about corporations. Can a company enter into contractual obligations? This is very important. Under the case of Salmon versus Salmon, it is an English case. It was stated that a company upon incorporation becomes a body corporate distinct from the people who are involved in coming up with it. That is, its members and shareholders. That is the beauty about registering a company. When you register a company, you are distanced from the company. Why? Because a company upon incorporation, it becomes a body corporate. It attains what we call artificial personality. It attains what we call rights and duties which are similar to those of a natural person. Like the right to sue or be sued. Like the right to buy property. Like the right to hire employees to work for it. In actual sense, that company can even hire its shareholders to work for it. Which literally means that after incorporation of a company is separated from the people who are involved in coming up with it. That is why a company can even survive. It can continue executing business even upon the demise, upon the death of its original shareholders. So what are we trying to say? An incorporated company can enter into contractual obligations. It can enter into contractual obligations. Actually, when you look at its rights and duties, the rights is attained upon incorporation, like buying property. When it enters into a contract with a seller, then that is a legal contract. When it enters into a working contract with an employee, that is a legal contract. When it goes to a bank and gets a loan, that is a legal contract. That is what we talk about. Well, that's what we mean by capacity of an unincorporated company or a corporation. Let's note that corporations, these are artificial persons recognized by law. Corporations can take two basic forms. Corporations may be created by statute, written laws established by acts of parliament, or through registrations or statutes. Very important. Very, very important. And then we need to talk about the minor principle. A minor is a person who is below the age of majority. And the age of majority in Uganda is 18 years and above. Different domiciles have different ages of majority. Even in the United States, there are ages of majority. In the United Kingdom, there are ages of majority. In South Africa, in Tanzania, in Kenya, there are different ages of majority. So let's analyze the minor principle. A minor principle is defined by the Contract Act as a person who, a minor is defined by the Contract Act as a person who has attained the age of 18. Contracts entered into by a minor may be valid and they may be binding on that minor. However, a minor can opt out of them. It has been stated that for purposes of contracting, a minor is a person who is under the age of 18 years. Contracts made by a minor avoidable at his option. He has the will. The law protects him to the extent that he can agree to the contract, or he can allude to the fact that he was coerced into the contract. He was coerced into the contracts. However, there are contracts which may bind a minor. And these are contracts for necessaries, necessities of his livelihood. Contracts which help in the running of life, the daily running of life of the minor. Necessities of life. For example, what are some necessities? These may include food, clothes, medical care, school fees, shelter. All those things are necessaries for a person's way of living. And Section 57 of the Contracts Act 2010 is very clear. Now let's define necessaries for purposes of interpretation. That in defining necessaries for the purpose of interpretation, it should be noted that minors are restricted to necessities of life. A minor is liable on these contracts of necessities of life, and there is no way he can run away from such contracts. There is no way he can run away from such contracts. And the above principle was illustrated in the case of Nash versus Inman. It's a case of 1908 to 1910. All England Law Report at page 317. The defendant, upon being sued for clothes supplied to him while still a minor, argued that he was a minor at the time the goods were supplied. I think these were a number of jackets. And that the goods were not necessaries, as he was already well supplied with clothes. Court held that the clothes were not necessaries within the act, and the defendant was not liable to pay for them. So court in the above case found out that the courts the minor had demanded for were not necessities. They were luxurious, and there was no way someone would claim from the minor. So I believe that with above slides, my business and students, my business students, and legal scholars have been able to appreciate the principle of capacity contract. There's a lot I would have loved to say about the same principle, but that is all I can say at the moment. Thank you very much.